Hello, everyone. My name is Richard Aikens, and I have the good fortune to be able to chair this online commercial seminar given by members of Brick Court Chambers today. And as you will have seen from our program, we have got 5 speakers. They're each going to give a short 10-minute talk. You are invited to ask questions. Please put them on an email, send them to Paul Gray, and then I can relay them. I'm sure they won't be quite as cutting as some of the questions that have been asked by journalists in the daily broadcast from number 10 Downing Street, but we do want interesting questions. These are interesting times, they raise interesting issues for the law, and we're here to discuss them now. Now, I'm going to start by Salzido, QC, our first speaker. Simon is a commercial silk with a broad practice. Together with Andrew McIntyre and Sophie Shaw of Brick Court Chambers, he's recently completed the draft of a new book called Fraud and Breach of Warranty, which is about business sale litigation. And this book is going to be published next year. So, Simon, over to you on fraud and breach of warranty, business sales claims in the age of COVID.
Thanks very much, Richard. Thank you, everybody, for tuning in. Challenge to get through fraud and breach of warranty in the age of COVID in 10 minutes. I shall do my best to say, give a tour d'horizon of the landscape rather than focusing too hard on interesting points. And I'll introduce you to a brand new phrase. I now call these Fabo claims after the title of the new book. So on the first slide, we have a picture of a dictum which I suspect everybody will be familiar with, the dictum of Buffett W, that it's only when the tide goes out we find out who's swimming naked. It may be slightly unfair to apply that to the COVID situation, where the tide is not so much going out as removing itself in a kind of reverse tsunami, leaving probably even those with perfectly decent swimsuits a little bit nervous and a little bit embarrassed. On the next slide, I put out the toolbox of the buyer who finds that for whatever reason, the business that they have purchased turns out not to be such a great deal as they thought it was. And that, of course, is going to be happening to more or less anybody who's bought a business in the last couple of years. And that's why I think this is something worth talking about now in the light of COVID, because so many markets will have plunged. So the main types of claim that a buyer might want to bring in these circumstances: breach of warranty, perhaps the most obvious one, claim on indemnities if there are any, a claim for misrepresentation under the Act, and I'm not going to say much about that, but just to say, you'll recall, I expect, that requires a misrepresentation which is in effect negligent. If you can go further and say that the misrepresentation was fraudulent, then you have a fraud claim, which may be even more valuable for reasons that I will discuss in the 10-minute slot. And it's conceivable that frustration might even apply to these kind of transactions, though I'm not going to go into that now, but you'll hear a bit more about that later in the seminar in general respects. On the next slide, we've got just a couple of points that I think are worth making about breach of warranty claims. The first point at the top is the most important. The actual terms of the warranty really do matter. They are not all the same as each other. You should not assume that because there's a previous case that dealt with a slightly similar warranty, or even a very similar warranty, that will be decided in the same way. First impressions are not necessarily right in this field. It's very important to consider the actual terms of your warranties in their context of their actual agreement, SPA, or whatever else. The second point I would make in relation to breach of warranty claims in a 10-minute tour is that a decision which may become quite important in relation to COVID claims is Macquarie against Glencore. You've got the reference there. It was a case that went up to the Court of Appeal where there was a warranty in the usual kind of way that the accounts were correct, true and fair view, all of that stuff. And it turned out that there was a significant liability that the target company directors did not know about at the date when the accounts were signed. But if they had known about it, it did exist at the date the accounts were signed, and if they had known about it, they would have had to have provided for it. So the question is, does that make the accounts wrong, not true and fair, etc.? The Court of Appeal held that it did not, in favour of the seller, that true and fair accounts are accounts prepared in accordance with accounting standards on the basis of the knowledge available at the time the accounts are signed. So that case, it seems to me, is quite likely to be one that may feature in post-COVID FABO cases. So useful to be aware of. And the other big point about breach of warranty claims that I think may be worth highlighting is that there are two quite different types of warranty which have quite different consequences in terms of proving loss and damage. And there's the case of Lion Nathan against CC Bottlers, which was a Privy Council case on appeal from New Zealand, where Lord Hoffman gave a judgment which is important on a number of issues of damages. But for FABO cases, what's quite important is it makes it clear that a warranty that says that a particular set of management accounts or projections have been prepared with proper care is treated as a warranty of process, and it has the similar effect to giving the buyer a potential negligence claim, because it effectively means that reasonable care has been used, and the consequence therefore is a rather different measure of damages to a normal kind of warranty. So it's well worth being aware of that key difference. On the next slide, I've got a few quick headline points about fraud claims. Fraud claims are very important in FABO cases. The key reason why they are so very important is because in many well-drafted SPAs, the boilerplate exclusions and entire agreement clauses mean that that there's no other way of relying on representations, and they may be key because there may be no breach of warranty. So fraud is often needed to give you a claim at all as the buyer. Also crucial is that fraud claims have a different measure of loss, because they have the tort measure of loss. So you're put in the, so with a warranty claim, you're put in the position as if the warranty had been true. So you still have the company, but it was that the accounts were right. In a fraud claim, you're put in the position as if you had not been the subject to the fraud, and in fact, as if you had never entered into the transaction. So the transaction is reversed, and that gives much more powerful damages for a claimant if the bargain has turned out to be a bad one for reasons that may have nothing to do with the fraud. And that's why I've used this opportunity to put the little picture of the COVID virus, which everybody seems to use for everything these days. So if it turns into a bad bargain, fraud is important. Other key headline points to make about fraud claims. First, in English law, the courts are very strict that fraud must be proved against an individual who both makes or is responsible for the representation and is dishonest, actually fraudulent in the sense explained by the House of Lords in Derry and Peake a long, long time ago, but still applied. And the other key point I would make about fraud claims is it's often important to consider who, other than the individual fraudster, may be legally responsible for the fraud. And in that respect, there are two key authorities to be aware of. There's an old House of Lords case, Breeze and Woolley, where all the sellers appointed an individual, the managing director, to go and negotiate on their behalf. The managing director was the only one who knew about the fraud, and that meant that all the sellers ended up liable for it because they'd authorized him to speak for them. Man and Freightliner, slightly different case, where the fraudster was lower down but was invited into negotiating meetings, thereby again the vendors became liable. I'm already getting close to the end of 10 minutes. So next slide, is a couple of other points just to bear in mind. If you are advising a buyer on possible claims, watch out for notification clauses. They are strictly enforced, they're often there, and they can give rise to much shorter limitation periods than you expect. Always look for them in the SPA as the very first thing you do. Rescission is available in business sale cases. People often wrongly assume it's not. And remember to consider claims against advisors who may also have shorter time limits, potentially through their engagement letters. And finally, here is an advert for my book, which Richard wrongly said was out next year. It's out this year. This morning, the drafts went to the publishers, so it will definitely be out. You can safely pre-order now, and there is the details for you to find it on the website. Thanks very much for listening.
Simon, thank you very much indeed, and many apologies for saying that it was coming out next year and getting behind myself, as it were. Now, I haven't got any notice of any questions that have come in for you, but I've got a question which maybe you could Winter. You mentioned notification clauses and how they are strictly enforced against buyers. What's the position with notification clauses if the allegation is fraud?
They generally won't apply. Fraud can get you around that as well, because they very rarely have anything explicit to say about fraud. And so the essence of a fraudulent misrepresentation claim is that it impugns the whole agreement and the buyer's consent to the whole agreement. So it should normally get you out of the notification provision as well. Another reason why fraud may be essential.
Now, to make it more topical even, what about an allegation or an attempt to get out of it by saying the contract's been frustrated? Things have changed now so much because of the coronavirus, etc., and you want to bring in frustration. Does a notification clause apply to that?
Very good question. Don't know, Richard. I'm very happy to think about and research that question for anybody who'd like me to, but at the moment I don't know.
Well, it just may be that's a topical thing, given the words coronavirus, COVID-19 and frustration have been linked together quite often in discussions that one has come across.
No, you're right, Richard. I can say one thing, which is it will of course depend on the construction of the clause, and most of them will not say anything that might suggest they cover frustration. So it may be that, like fraud, they wouldn't do, but you need to look at the clause.
Yeah. Rule number one in any commercial litigation: look at the clause and construe it carefully first of all. Okay, well, as we haven't yet got any questions, I think we should move on to our next speaker, who is Stephen Midwinter. Now, Stephen reminded me when we were preparing for this that he and I first met when he was doing pupillage in Brick Court back in 2002, and I was sitting in Southwark Crown Court on some criminal case, and he came to observe this for some long time. Well, Stephen's come a very long way since then. He's now a silk, he has a broad commercial practice, and he's going to speak to you now on the issue of insurance claims in a period of pandemic. Stephen, over to you.
Thank you, Richard, and thank you for reminding me of how long I've been at the bar. It's fair to say that there's scarcely a part of the insurance market that will not be affected in one way or another by the coronavirus pandemic or by the extraordinary international government reactions that it has provoked. And I could talk, for example, about how claims directly or indirectly linked with the virus might affect the life insurance market, travel insurance, liability insurance, commercial crime, D&O, even motor insurance. But I'm going to concentrate in my 10 minutes on two topics which seem from the instructions that I've been receiving to be of the most immediate relevance to the insurance law community, both because of the potential scale of claims involved and because they give rise to particularly legal issues. And they are A, business interruption policies, and B, the aggregation of pandemic-related claims for the purposes of claiming on reinsurance. So taking business interruption insurance first, it's hardly surprising that in a situation where large parts of the economy have been ordered or forced by circumstances to close or radically alter the way that they do business, thoughts turn to business interruption cover. And for those who don't know, business interruption insurance is insurance which covers loss of profit caused by the fact that a business can't trade as it usually would as a result of an insured peril. Business interruption insurance generally takes one of two forms. Firstly, it's very commonly provided as a section of cover in business property insurance. And secondly, more rarely, it arises as a specialist form of contingency or event cancellation insurance, which is taken out, for example, by organisers of major sports events or cultural events, or I understand by Hollywood film producers. And the first and most important question that's being asked in the current situation is whether these kinds of policies are going to provide coverage for lost profits caused by the virus and or by the government measures that have been put in place in response. And the short answer, happily for those who make their living in this field, is that there turns out to be a very large variety of different policy wordings in this area, and the arguments for and against coverage are going to vary depending on the precise policy terms. Even what appear to be relatively minor differences in the way that coverage is expressed could turn out to be crucial. At one end of the scale, there are some policies that explicitly include cover for loss caused by an epidemic. Most of those are the specialist contingency type policies, though I have heard in one case of one industry body whose standard business interruption policies explicitly include pandemic cover. Where there is explicit epidemic or pandemic coverage, it's likely that the basic issue of coverage will be relatively straightforward. One would, on the face of it, expect coverage to apply. At the other end of the scale, the business interruption insurance cover in a standard property policy very often includes a material damage proviso, which provides that the business interruption cover only kicks in consequent upon physical damage to the insured premises. The ABI and the FCA have both set out that their understanding is that the vast majority of business interruption policies in the UK are written on that basis. And since neither the virus nor the government's orders in response are likely to have caused physical property damage, save in the most minor or extreme cases, it seems on the face of it unlikely that the majority of these standard policies will respond. Of course, one should never underestimate the ingenuity of lawyers when faced with a particular wording, but that seems to be the starting position. Between the two extremes, there lies a range of policies giving rise to more difficult questions, where there's no material damage proviso, but the list of covered perils doesn't explicitly include epidemic or pandemic cover. There's very little general guidance that I can give on this. There aren't decided cases about how these particular clauses are to be interpreted. Everything is going to turn on the particular policy wording, and it's going to be construed in circumstances which are unlike anything that we have seen before. I've already seen a great variety of clauses with sometimes very subtle but very important differences in wording. For example, many business interruption policies contain extensions for business lost as a result of a notifiable disease, and COVID has been listed as a notifiable disease in the UK. But the coverage often only applies where the disease is found on the premises or in the vicinity of the premises or something to that effect. And it seems unlikely that there will be many cases where COVID has been found on the insured premises. There may well be very interesting arguments to be had as to whether COVID has been found in the vicinity of insured premises. The term in the vicinity is obviously one about which one can take a different view. And we've seen a debate brewing in press reports about Hiscox's cover as to whether that is going to apply. The point that Hiscox refers to in its response seems to be that its coverage is restricted to diseases on the premises or in the vicinity, and that won't include coverage for COVID losses. Other policies contain extensions for loss caused by government action or by orders of a recognised authority or something to that effect. Those clearly have the potential to apply here when government has ordered businesses to shut down. Though again, we see that in some clauses, they are limited to orders made following a disturbance in the vicinity of the premises or something to that effect, or orders which prevent access to the particular premises. And again, one can see the scope for arguments as to whether these types of clauses are broad enough to cover COVID-based claims. I incidentally think that there is a fear in the insurance market that there will be pressure on judges to give these kinds of clauses a wide reading so that businesses don't find themselves with no recourse in circumstances where they are suffering very badly. And while I can understand that fear, and also the reputational pressure that insurers feel under more generally about these claims, I don't think it would be fair to suggest that judges are likely to be influenced by that sort of argument. My own experience has always been that English commercial judges are genuinely not swayed by those kinds of floodgates or hard case type arguments, and they will be looking closely at the wording of each individual policy. That then is coverage. The second big question when facing a business interruption situation is whether the loss falls within the covered peril. That may seem to be a common sense proposition, but the importance of the point is illustrated by a well-known case, the Orient Express Hotels case, in which the insured sought to recover losses to its hotel business based in New Orleans in the wake of Hurricane Katrina. The case went to arbitration, and the arbitrator held that there was a distinction to be drawn between business losses that resulted from damage to the hotel, which were covered, and business losses related to the fact that fewer tourists were going to New Orleans in the wake of the hurricane, which were not covered, irrespective of any material damage proviso. There's obviously scope for that to apply in spades in relation to pandemic claims. There will be cases where claims could be made where the real underlying cause of loss is an inherent weakness in the business. And one can think, for example, of cases of high street stores that would have been struggling anyway, and where the virus may have precipitated a loss to the business that was going to be suffered in any event. And going forward, once lockdown is eased, there may well be situations in which there have been changes in consumer behaviour in the long term. We see Marks and Spencer, for example, were reporting a suggestion that retail will have changed forever, where it will not be possible to say that the loss to the business is caused by the virus, where the real proximate cause may be a change in people's behaviour in the wake of the virus, and not whatever it is that is the insured peril. There'll also be a need for insurers, of course, to take care to check that insureds are complying with the policy's requirements as to what they do to minimise losses. For some businesses, there's obviously very little that can be done in the current situation where they've been ordered to close. But for others, for example, those pubs and restaurants who are able to offer takeaway business or collect business, there may well be steps that they can take to minimise their losses, which insurers will want to make sure are being complied with. And that's for two reasons. One, of course, is that an insurer who settles claims without carefully considering these sorts of points will find itself paying claims that it needn't have paid. The other is that if an insurer doesn't take care to ensure that it's only paying covered losses, it may well find itself accused of acting in an unreasonable or unbusinesslike manner, entitling its reinsurers to assert that loss settlements are not automatically binding on them, and leaving the reinsured to prove that each loss is covered. That then brings me on to the question of reinsurance, which I'll deal with very briefly. And for many insurers, a vitally important question is going to be whether, if they are liable to pay claims, they can recover on their outwards reinsurances. It could well be business critical for some small insurers. And aside from the need to ensure that claims paid fall within the scope of cover, and that all reasonable and businesslike steps have been taken to adjust claims, an important question is going to be whether claims can be aggregated. Many reinsurances will apply a per event or per occurrence or per catastrophe deductible, and COVID claims, business interruption claims, are likely to get over those deductibles only if they can be aggregated in some way. That is likely to turn on whether the losses can be said to arise out of one event, one occurrence, one catastrophe, depending on what the policy requires. That is a topic on which there is a great deal of learning in the case law, and where it is likely that counsel's advice or solicitor's advice is going to be necessary in order to try and reach a view It's much too broad a topic to try and cover now, but without trying to do that or to give the game away, there are some obvious possible answers. At one end of the scale, one might suggest that all coronavirus claims arise out of a single event. The pandemic is obviously, in one sense, an event, like in the cases there's discussion of the 100 Years' War or World War II being an event. That seems quite a broad definition, but it's possible that it may be an arguable one. Next, at the other end of the scale, it might be said that each individual loss is actually a separate event, and there's no real unifying cause or trigger that can be treated properly as a single event. Now that seems rather narrow, but one only has to consider the litigation arising out of the September the 11th attacks in New York to see that different ways of putting this are perfectly plausible. The Herald Glen case decided for the purposes of property insurance that each attack on each of the Twin Towers was a separate event. Other cases, the Simmons case decided that the costs of cleanup arose out of one event, and the Silversea case decided that costs of holiday cancellations, again, arose out of one event from 9/11. And so it is going to be necessary to consider what the particular coverage is dealing with and the particular circumstances of each case. Between those two extremes, there may be arguments that a government order is an event, maybe that each separate government order is a separate event. So, for example, in the UK, on the 20th of March, gyms and restaurants were ordered to close. On the 23rd of March, other businesses were ordered to close. They may each be an event. Or alternatively, taking one step further back from that, it may be that the spike in coronavirus cases which led to those orders could be considered the relevant event or occurrence or catastrophe. On top of all that, many reinsurances nowadays contain an hours clause, which requires claims to be aggregated if they occur within a certain period of hours. And the impact of that may be important, particularly if one's looking at a series of government measures or a series of businesses closing down over a period of time. As I say, there is a lot of law on that. It's probably something on which it's going to be necessary for most insurers to take legal advice and seek opinions. I'm conscious that I've gone over my 10 minutes, so I will sign off in what has become the traditional manner by reminding us all of the government's advice, with apologies to Matt Lucas. Go out, don't go out. Go to work, don't go to work, don't go out. Stay home, go out, save lives. Thank you.
Thank you very much indeed, Stephen. You have gone slightly over your 10 minutes, but I can't resist asking you this question, which is asking you to look in your well-calibrated crystal ball, of course. It seems to me, given all the press coverage that there's been, that there are going to be a large number of potential cases that will arise, both in relation to business interruption and probably on the reinsurance side. Do you think that they're likely to be the kind of need for grouping together particular topics which need decision in test cases in the way that the commercial court was able to do so successfully in the various issues that arose out of the very large Lloyd's losses, mostly from natural catastrophes in the 1980s, so that the market and insureds and reinsureds would have some, as it were, stock answers to stock questions?
Yes, I think that's a very realistic possibility. We know that already we understand there is a Hiscox insureds group getting together for litigation as a group. If it can be identified that there are a number of policy wordings that are not unique and which apply to different sections of the market, they're not all individual separate wordings, then one can see that absolutely a sensible way to deal with that may be to have test cases where a set of wordings are considered and the answers to these questions can be determined. They are relatively short legal construction points that it ought to be possible to bring on relatively quickly and decide together.
Good, thank you. Now, whilst I was speaking, a question has come in. Bugler of Wilkie, Farr and Gallagher. And his question is this: there are moves in the US to introduce by statute retrospective coverage under business interruption policies to pandemic risks. If this goes through, how would this affect claims under reinsurance contracts with, for example, UK reinsurers? And that's a bit of a fastball.
Yes, I mean, that is a fascinating question. As with all of these things, I can duck it by saying it's all going to depend on the terms of the policy. It will, for reinsurances, for example, depend on what is covered by the follow settlements clause, whether retrospective changes in the law come within that. Thinking back to the Wasser and Lexington case, even in situations where the reinsurance is back to back, if one gets a statutory change in the law after the date of the policy, it can mean that in fact the reinsurances don't respond. So that is a very good question. It will depend on precisely what is done, what the terms of the policy are. I think to say that claims will simply be covered if they're covered under the original insurance as a result of statutory changes is too simple an answer. There may well be defences that reinsurers can take.
And I suppose it may also depend upon what the applicable law of the reinsurance is as well, because the English law attitude may be different. Whereas if it was also US law, then that might have a different effect.
Yes, if you've got US law on the reinsurance, you're more likely to be stuck, I imagine, with the effect of US statutory changes. But the Wasser and Lexington case is quite a good illustration, where the underlying insurance was governed by the system of US law where a case was brought, and the reinsurance was governed by English law, and that did lead to different results. US statute said that cleanup costs were covered whenever they were incurred. English law didn't allow for that situation, and the result was there was no reinsurance cover, even in a back-to-back situation.
Well, good. Well, thank you very much indeed, Stephen. That's extremely helpful. And I think this is an area where we're going to see an enormous amount of activity in the course of the next months or years. Now, we're going to move on then to Nick Saunders, who is going to speak next on good faith and COVID-19. Nick is a rising silk. He's not quite like a cake, but he's certainly rising in the silk world, and he has a broad commercial practice. And in the last 3 years even, he's led over 30 cases in the Supreme Court, Court of Appeal and the Court of Justice, European Court of Justice, as well as being active in several substantial commercial trials. Nick, over to you.
Thanks very much, Richard. Over the last few weeks, our Prime Minister has been fixated with the R number, the reproductive value that can be used to track how many people on average will be infected for every person who has COVID-19. Get R down, he has said time and time again. But what about the R number for commercial disputes arising from coronavirus? There were dire predictions around the time that lockdowns were imposed that the courts would be overwhelmed with opportunistic claims, that the supply chain would be damaged, and there'd be terminations of contracts and so on. So I'm going to look for the next few minutes at whether good faith might be the commercial lockdown that unreasonable contracting parties might need. Could we have the next slide, please? Thanks very much. So back in April, Bickel held an interesting meeting involving Lord Phillips, Lord Neuberger and others, in which they called for a debate on the necessary contribution of law to safeguard commercial activity and minimise disruption to supply chains. They identified in a very short note that the civil law doctrine of unjustified enrichment might be relevant, as might the common law debates around good faith. More recently, we've had something from the Cabinet Office a couple of weeks ago on responsible behaviour in commercial contracts. The object of that is to ensure that the parties to contracts act reasonably and fairly, support the response to COVID-19 and protect jobs and the economy. Although over 4 pages, the note refers to responsible and fair behaviour 9 times, paragraph 14 is the only one that actually tells us what that means. It's being reasonable and proportionate, acting in a spirit of cooperation and aiming to achieve practical, just and equitable contractual outcomes. But of course, the note makes it clear it's guidance only and not intended to overcome any legal duties or obligations. So it is worth looking for the next few minutes at what those legal duties actually are. On this slide, it is an attempt at a taxonomy of duties of good faith. There are broadly 4 categories. There could be an express term. There are good faith duties implied at law. For example, classes of contracts such as insurance policies and contracts of employment. Good faith duties involving contractual discretions. That's where one party exercises a contractual discretion, often called braganza duties. Those may be a term implied at law by fact, or maybe even a manifestation of the equitable prohibition on a fraud upon a power. And then finally, there's good faith in relational contracts, whatever those are. The orthodox approach has been their terms implied by fact and are therefore subject to the necessity test. But more recently, it's been argued that some recent case laws cast doubt on that. I'm going to look for a few moments now at that relational contract category. The idea of a relational contract first came to prominence in English law following the judgment of Mr. Justice Leggett, as he then was, in Yam Seng. He said that relational contracts involve a longer-term relations between the parties. They may require a high degree of communication, cooperation, and predictable performance, and involve expectations of loyalty that are not legislated for in the express terms of the contract, but are implicit in the parties' understanding and necessary to give business efficacy to the arrangements. Now, of course, all contracts are relational in the sense that they set out the obligations between individual parties, and there's obviously a distinction between parties on the one hand, say, spot trading for a particular shipment of coal, and those in a 10-year research and development joint venture agreement. Where it becomes a bit more difficult is to see where to draw the line in the spectrum between those two extremes. And a related controversy, and the reason this matters, is because if you recognise a special category of a contract in the same way that insurance or employment contracts are, then the duties of good faith will be implied automatically. And they're simply a label, though they may be implied and take effect in a way that doesn't require you to satisfy the test in Marks and Spencer. So the categorization is very important, as is trying to work out whether something is or isn't a relational contract in the first place. Can we have the next slide, please, to Bates and the Post Office? Thanks very much. So the most recent significant case is the decision of Mr. Justice Fraser in Bates and the Post Office. That was a highly publicised case about a group of sub-postmasters who brought claims against the Post Office for breach of contract. Their contract had a few unusual features. The postmasters were required to use the Post Office's Horizon accounting system, and the contract provided that if Horizon indicated a discrepancy in the accounts, that was final. Lots of postmasters were then chased for the accounting discrepancies, and they alleged that the apparent shortfalls were not their fault, but the fault of errors in the software. And so this led to a very large dispute. In the common issues judgment, which is the one referred to on the slide, Mr. Justice Fraser decided that the contracts between the postmasters and the Post Office were relational, and that a series of terms ought to be implied into them. Can we have the next slide, please? Now, the judgment could be taken to suggest that relational contracts are now a legally recognised category of contract in which obligations of good faith will automatically attach, much like insurance contracts or contracts of employment. But that's been subject to a lot of criticism, most notably recently from Professor Paul Davis, who has gone through the cases relied upon by Mr. Justice Fraser and reached the conclusion that they don't seem to support that proposition. And perhaps the decision in Bates is inconsistent with Globe Motors, in which Lord Justice Beatson didn't seem to regard relational categories as a distinct legal category of contract. Now, what Mr. Justice Fraser identified were 9 factors which are form part of a non-exhaustive set of factors that can help identify whether a contract is in the relational category. There must be no specific express terms that exclude a duty of good faith being implied in. That's obviously a mandatory provision. And then the others are, as it were, discretionary factors. The contract will be a long-term one. The parties must intend that the roles be performed with integrity and with fidelity to their bargain, and so on. Can we have the next slide? And they go on, the spirits and objectives of their venture may not be capable of being expressed exhaustively in a written contract, repose trust and confidence, but not of the same sort as a fiduciary relationship, and so on. Now, as I said a moment ago, the judge was clear that wasn't an exhaustive list, but it won't have escaped your attention that it could be said that these criteria are very vague, and many of them overlap, and quite a lot of them are optional. And in consequence of identifying that that contract was a relational contract, Mr. Justice Fraser concluded that 17 incidents of good faith obligation should be implied, including a term that the Post Office would properly, fully and fairly investigate any alleged or apparent shortfall in the money collected by by postmasters. So a few practical points. If you encounter litigation involving long-term contractual relationships, I think there are a few points that could be drawn from Bates. If you want to invoke a duty of good faith, it's advantageous to you to try and adopt Mr. Justice Fraser's analysis of relational contracts and argue that the incidents of the good faith term ought to be implied automatically. If, on the other hand, you find yourself on the other side of the Bates argument, you'll be seeking to limit the good faith obligations that will be implied by the court. And it should be noted there's a great deal of uncertainty about whether Bates is really good law and indeed what it actually decided. Can we have the next slide as well when it comes up? When the Post Office applied for permission to appeal the judgment in the Court of Appeal, there was an oral permission hearing before Lord Justice Coulson. One of the grounds for the appeal was that Mr. Justice Fraser erred in implying the good faith term automatically from the classification of the contract as relational, rather than implying the business efficacy test. But the paragraphs of the order declining to give permission, Lord Justice Coulson rejected that submission and said that Mr. Justice Fraser implied the good faith terms on the basis of the particular contract, i.e. they were applied by fact. So it might be said that Lord Justice Coulson's interpretation of the reasoning in Bates is quite difficult to reconcile with the way that Mr. Justice Fraser actually reached those conclusions in his judgment. And it's certainly at odds with the analysis of several academics who've been very enthusiastic about the first instance decision of Bates as being a clear authority for the proposition that relational contracts are now some special category of contract in which good faith terms will be implied at law. Lord Leggett, as well, speaking very recently, appeared to regard Bates as having developed the law to a point where duties of good faith may well be implied automatically from the identification of particular contracts as relational. So, but stepping back, I think it's perhaps not entirely surprising that Lord Justice Coulson reached the conclusion he did. The merits of the Post Office's case were hardly attractive. It was effectively arguing for strict civil liability of the sub-postmasters, notwithstanding the fact that they were not at fault for the discrepancies that they've been subject to. So perhaps Bates is best viewed as yet another example of hard cases making bad law, and it may be consigned to history. Unfortunately, the uncertainty it's generated will prove, no doubt, fertile ground for litigation and appeals, including things coming out of COVID. It seems to be traditional in this now to finish with something our Prime Minister might have said about the how to deal with the virus. So stay alert, watch out for relational contracts, and save the courts.
Nick, thank you very much indeed for that. I don't think we have got a particular question to put to you, so I'm going to provide one for you. And there's obviously an element in this new contract term, relational contract, where the length of the contract and the importance to the parties is an element. So three different types of contract which we come across a lot in terms of being commercial lawyers and commercial litigators. And your quick yes/no answer to whether or not you think they might come within the term relational contract. Long-term supply of goods, number one. I don't mean just 10,000 tons of coal, as you suggested, but a 5-year contract for that between a particular supplier, a particular buyer. A long-term charter for a ship, 10-year contract, as they used to be, but still around. And a long-term supply of services. As I say, yes/no answers probably is all we've got time for now.
I think so. Long-term supply of goods, repeated contracts, probably no. If anything, there's a mechanism for that in course of dealing type analysis. Charter for a ship, possibly, and supply of services, possibly yes, on the test that, because if the services are to be provided, there are dependencies and obligations on both sides in order for the services to be performed, then applying the sort of approach that Lord Legate, as Mr. Justice Legate, as he then was, identified, then you're squarely within the sorts of things that would make you a relational contract.
Yeah, well, interesting times. We will see. Thank you so much, Nick. Now, next on our list is Zara Al-Rikabi. Zara, hello, Zara.
Hi.
Zara was, I hope she'll forgive me for mentioning this, selected for the Lawyers Hot 100 in 2020. So a great distinction. Zara has a broad practice encompassing commercial litigation, public international law, and public law. And here for her contribution today is something which involves all three of those: frustration of contract, radical differences, and supervening illegality.
Thank you very much, Richard.
Zara, over to you.
Thank you very much. So, I mean, frustration has been a very big topic since the start of the pandemic, and there's been lots of very good, I think, material online setting out the test for frustration and describing how it could apply in the current circumstances. So I thought I would use my 10 minutes to highlight a couple of issues where the law may be in some flux. And I thought that might be something quite useful to keep an eye on when advising clients on merits of whether frustration applies to their particular circumstances or not. So the two issues that I've picked up from the judgment of Mr. Justice Marcus Smith in Canary Wharf and EMA are first the juridical basis of the doctrine, and that's not merely of intellectual or theoretical interest. It has a very practical consequence since it's relevant to what evidence is admissible before the court in deciding whether the contract has been frustrated. And the second issue I'll touch on very briefly is supervening illegality. So starting with juridical basis, the test for the formulation for frustration of contract that has stood the test of time is Lord Radcliffe's test set out in Davis Contractors Limited. And it's essentially, this is not the promise, this is not, it was not this that I promised to do, because the change has been such that the circumstances have radically altered the nature of the agreement. This has picked up again the same formulation, approved and expressed slightly differently in, sorry, I missed, okay, so I'm missing a slide, but in Panalpina, so the House of Lords, sorry, in Panalpina picked up on the test in Davis Contractors Limited and approved it, expressing it slightly differently. that it's essentially the same exercise, which is looking for whether, as a result of circumstances falling outside both parties' hands, the nature of the obligation has been radically altered. And the House of Lords and Panel Pina specifically says it can't be just more onerous, it can't be just more costly, it's got to be a radically different obligation to the one the parties had agreed to. The modern formulation of the test is set out by Lord Justice Ricks in the Sea Angel, and this is the one that I'd like to focus in slightly on, because it was picked up by Mr. Justice Marcus Smith in Canary Wharf and the EMA, and it's what he says about this test that I think it is quite interesting to think about. So the test set out by Lord Justice Ricks is, in my judgment, the application of the doctrine of frustration requires a multifactorial approach. Among the factors which have been considered are the terms of the contract itself, its matrix or context, the parties' knowledge, expectations, assumptions, and contemplations, in particular as to risk, as at the time of the contract, and at any rate, so far as these can be ascribed mutually and objectively, and then the nature of the supervening event, the parties' reasonable and objectively ascertainable calculations as to the possibilities of future performance in the new circumstances. So this sets out essentially the different ingredients of the radical difference test. So how do we know whether the nature of the obligation has radically changed? And Lord Justice Ricks here sets out the different ingredients of that test. In Canary Wharf and the EMA, so they were just the wrong way around. Here's the Panel Pina, but I've already covered that, so I'll skip it. In Canary Wharf and the EMA, Mr. Justice Marcus Smith repeats the quotation that I just read out from Lord Justice Ricks, and he describes Lord Justice Ricks as having identified various factors that are relevant. The first being the terms of the contract itself, the second being the matrix or context of the contract, and the third as a separate thing to matrix, contractual matrix, so as an entirely separate exercise, identifying the parties' knowledge, expectations, assumptions, and contemplations, in particular as to risk, as at the time of the contract, etc., etc. And what he says in relation to this third category is that it may include looking at mutual negotiations of the parties and their declarations of subjective intent, matters which are not to be taken into account when interpreting a contract, yet they are relevant in the case of frustration. And so Mr. Justice Marcus Smith held then in Canary Wharf and the EMA that one could have regard to pre-contractual negotiations in determining what the parties' knowledge, expectations, etc. are. And when one looks back at the Sea Angel, one would see that Lord Justice Ricks was not addressing that issue in particular. And so it leaves open the question whether, in fact, it's wrong to interpret his dictum as opening up a door to bring in as admissible evidence in the context of a frustration case, pre-contractual negotiations and things falling outside the usual way that we construe contracts. And in my view, those things shouldn't be brought in, because when you look at what it means to say that the nature of the obligations has radically changed, there's a three-stage process. The first stage of that process is to say, well, what were the nature of the obligations? What did we agree between us as the two parties? And then what is the nature of the supervening event? What has happened? What do we reasonably foresee the impact to be? And then to compare these two scenarios and then make submissions as to whether they are so radically different that you could consider the contract to have been frustrated. When you look at it that way, there is no need to take into account anything that you normally wouldn't take into account when construing a contract. And so going beyond would bring us back to a time, and there are a number of frustration cases which have since been considered an unhelpful way to understand the test of frustration that Mr. Justice Marcus Smith himself considers in the case, which is to look for the fundamental purpose of the contract or something along those lines. It brings you back into that analysis, which is unhelpful because it's difficult to know what the parties would have done if they knew about the frustrating event, because by definition, they didn't contemplate it. And that's why it's capable of being a frustrating event. So that's the first thing I wanted to touch on briefly. And I think it's an interesting one because there's currently High Court authority saying you can look at this evidence. And but if you do seek to rely on that, I think it's worth bearing in mind that that might not be the right analysis, and that it might be possible to challenge that analysis. And then just very quickly, one of the issues that was considered in Canary Wharf and the EMA was the scope of supervening illegality as a separate head of frustration. So obviously there could be illegality that changes the nature of the obligations, and then you're back in that field of trying to weigh, what did we agree, where are we now, how much has that changed, and can we say that the nature of our obligations has radically altered such that it would be unjust to hold the parties to their bargain. And in Canary Wharf and the EMA, both sides so the EMA relied on various arguments, various quite novel arguments about the capacity of the EMA to carry on paying rent in the United Kingdom once the United Kingdom leaves the European Union, and various other arguments along those lines. And their argument was that if it became ultra vires for the EMA to assign its lease, for example, to assign its interest, if it became ultra vires for the EMA as a matter of European law, as applied in domestic law, then that ought to fall within the definition of supervening illegality, not only if it became unlawful for the EMA to actually pay rent. So, whereas on behalf of Canary Wharf, what we were arguing is that this is a much more limited concept, and it's only when the actual performance of the contract gives rise to criminal, quasi-criminal consequences can you say that the contract has been frustrated by supervening illegality. And the judgment isn't entirely clear, in my view, as to why the concept ought to be broader. I've included the quotation here, in which the judge says that he makes clear that in Patel and Mirza, the court was addressing illegality in the narrower sense identified above, and that this doesn't affect enforceability of contracts that contrary to public policy for other reasons. But I'm not entirely clear what other reasons could be, and how they are able to operate in this sort of much more clear-cut way, rather than being an element that you put in the balance under the Sea Angel sort of multifactorial assessment. But to be able to say it's unlawful and therefore it is frustrated, so a much more straightforward analysis, it's not clear to me what beyond performance being illegal could fall within that test. So I thought it's just something worth flagging up. I don't know the answer. It's an interesting one to look into, but just to flag up that it's a potential kink in Canary Wharf and the EMA that's worth keeping an eye on when advising clients on that question.
Laura, thank you very much indeed. That's extremely interesting. Alas, we haven't got any questions that have come in on the emails. But just looking at this, and I agree with you, by the way, that those statements by the judge that you quoted there are far from clear. They don't really help lawyers advise their clients in a way that's clear. But it seems to me that, and this is what I want to see whether you agree, that really we, for present purposes, looking to see whether a contract has been frustrated by the coronavirus events, there are three broad categories that lawyers are going to have to advise on. Has the contract become illegal to perform? Area number one. Has the contract become impossible to perform in a physical way, not a legal way? Thirdly, is the method of performance something that has become so radically different that it isn't what the parties contemplated under their contract? Those remain the areas that lawyers advising their clients have got to look at for the purposes of frustration in the present context. Yeah,
no, I agree with that. I think to adopt the usual cop-out about the terms of the contract being crucial and key, really, you know, it's very important to look at what it is that's being affected by COVID, for example. So that to use a land law example, because it's a property example, only because the EMA case was a property case, not because I'm a property lawyer. So take everything I say about property with a pinch of salt. But because to use a property example, for example, we've currently got regulations that have compelled businesses to close down. So we know that it's illegal for a shop, for example, that isn't selling essential goods to be open and to be selling products. But that's, if you are looking at whether a lease has been frustrated, so the lease for the shop has been frustrated, that's not the kind of illegality that actually affects the performance of the contract. So the performance of the contract is I give you an interest in my land and you pay me rent. And the legal regulations in this context don't affect either of those two aspects. It's the kind of illegality that may go to the nature of the obligations that we've taken on, that we say, you know, the circumstances have altered so much that this isn't the bargain that I've signed up for. And so you end up going to a different category of analysis. But where the lease has a positive provision regarding use, so if the lease said, you must keep you must use this property as a restaurant, high-end restaurant, and it must remain open at all times, or something along those lines. And again, excuse my relative ignorance, property law, but one of the decisive factors in Canary Wharf and the EMA is that while the lease had a negative user clause, it didn't have a positive user clause. It didn't say that the EMA had to use the property as its headquarters. It only said that the EMA couldn't use the property for various purposes other than office buildings, etc. And so I think it's very important when you do advise on frustration to look very carefully, as with anything to do with the contract, to look very carefully at the terms of the contract. And it's the terms of the contract that essentially identify what is relevant for the multifactorial assessment that Lord Justice Rick says you then have to carry out in order to decide whether frustration is appropriate.
Brilliant. Thank you so much indeed. Right, now we move on to our last speaker, Sarah. Hello there. Sarah is going to talk about dealing with breaches of injunctions during the current COVID-19 health crisis. Sarah was called in 2013 and is a newcomer to Brick Court. Sarah only joined us in February this year, and so for many of us, we've hardly had the chance to see you around in Brick Court. So this is a wonderful way of being able to introduce you, as it were. Sarah has a large practice covering all aspects of commercial dispute resolution and public law, and she has a particular expert preemptive remedies rather. So her talk is going to provide us with reminders of the key tools available for the enforcement of injunctions, that's to say, unless orders and committal applications for contempt of court. And Sarah will also discuss how the court has been dealing with enforcement of injunctions in practice since the UK lockdown. Sarah, over to you.
Thank you, Richard. Good afternoon, everyone. I have prepared just a short practical talk on how to deal with injunctions during this health crisis, as Richard has mentioned. So if we can turn to the first slide, I'm going to try and truncate this slightly because I'm mindful of the time. So this just gives a basis for why I thought it was an interesting talk. Fraud was on the rise already before this health crisis. It's not hard to see why the situation will provide fertile ground for more fraud. And this means that as civil fraud practitioners are going to be kept busy with increasing numbers of injunctive relief, and with there being more orders for more injunctions, there will be more breaches of those injunctions. And so that's why I thought it would be interesting to look at enforcement and how to deal with some of the practical difficulties of the UK lockdown. So if we can turn to the next slide, we can skip over this one very quickly. It's just a reminder of what an injunction is. Typical examples are freezing orders and search orders. So if we can go on to the next slide. The first key enforcement option in the event of a breach of an injunction is to obtain an unless order or a debarring order. The need for compliance is repeated in the order, and the threat of a sanction is levied in the event of a continued non-compliance, such as judgment being entered against the party in breach. Because of the draconian nature of injunctions and the seriousness of the underlying claims and the sort of allegations that you have typically involved wherever a court grants an injunction, a failure by a defendant to comply with it will also therefore be treated very seriously. It's not going to be equated with a failure to comply with other orders providing for general directions to trial, for example. The courts will therefore be willing to strike out a defence of a claim where an injunction has not been complied with because of the risk of real injustice to the other party. So if we can move on to the next slide. The ultimate weapon for enforcing committal applications, the ultimate weapon for enforcing injunctions are committal applications for contempt of court. And these are done pursuant to Part 81. This slide and then the following two slides, I've included a checklist for what you need to have in order to bring an application for committal. I'm not going to go through all these bullet points. Many people will no doubt be familiar with them, and you will have access to the slides after this talk. On this slide, it's worth noting that typically there is personal service of committal applications and the underlying order itself, albeit there is a provision to dispense with personal service if the court thinks it's just, and it's a very wide discretion that it has to do so. So if we can move on to the next slide, this is simply to make clear that naturally the contemnor, the alleged contemnor, has to be in breach of an unambiguous order. They have to have failed to act or have acted in a manner which was a breach of the injunction, and they must know that what they have done was a breach. And Masri provides an excellent summary of what knowledge the alleged contemnor must have. It's not necessary to show that the alleged contemnor acted knowing that what they were doing was a breach of an order or intending to breach the order. These matters simply go to sentencing. We just need to have knowledge of these two aspects on this slide. So if we go on to the next slide, this just sets out the procedural requirements for the application notice itself for committals. And again, these slides will be available, so I don't need to go over any aspects of this. So if we go on to the next slide, the pros and cons of whether one pursues an unless order or goes for the sort of absolute sanction of a committal application, is naturally fact sensitive. Debarring orders are much cheaper, much quicker, and they can still be very effective. Committal applications can themselves lead to very expensive, very protracted satellite litigation. There are regularly appeals because permission is not required. It's given as a matter of course, where someone is imprisoned for breach of an order. And so it has to be weighed up quite carefully as to whether it's worth going for a committal application. Where there's an obvious case, so there's a failure to comply with disclosure obligations pursuant to a freezing order, that's a situation where committal may well be the way to go. So if we move on to the next slide, looking at the impact of the COVID-19 health crisis, we're all no doubt familiar now with the new practice direction 51ZA, 51Z and 51Y that have been introduced recently. Here I've included the fact that extensions of time can be given by agreement of the parties, and that the impact of coronavirus is a factor to be taken into account. So plainly, where an individual is in breach of an injunction, we must consider whether any of the excuses which may be put forward based on coronavirus have actually impacted on their ability to comply. However, the attitude of the senior judiciary is that very much the show must go on, and parties should therefore be cautioned strongly against assuming that adjournments will be granted as a matter of course, in particular in relation to injunctions. And I've got an example here of a case on this slide that just gives an example of the court's attitude, and that being in the TCC. So if we move on to the next slide, since the commencement of lockdown in the UK, there have been 6 reported cases where the courts have dealt with committal applications. The most interesting ones, in my view, are the matters of Frejek and Yuzu Hair and Beauty. So I'm going to just discuss those. In Frejek, there was a hearing on the 7th of May, and the court heard a committal application via Skype, which related to failures by a former executor of a will for failure to comply with an order for delivery up and for disclosure. So the breaches occurred pre-lockdown. There were also some previous hearings that dealt with the dispensement, for example, of personal service. The court at the hearing on the 7th of May made findings of fact in the absence of the respondent, and the respondent was found to be in contempt on all 4 grounds. A bench warrant was issued for the arrest of the respondent pending consideration of the sanction. So, as I say, business as usual. Then in Yuzu Hair and Beauty, this is the most recent decision that we have. A committal application was issued relating to failures to make disclosures pursuant to a freezing order. The hearing was on the 13th of May before Mr. Justice Mann in the Chancery Division. And the freezing order itself had been obtained on the 30th of January 2019. The committal application was launched 8th of March 2020. So again, we have breaches of the freezing order which had commenced pre-lockdown, but then persisted during the lockdown. What's particularly interesting about this decision is that there was a history of non-attendance of various hearings by the respondents. So there had been various last-minute adjournment applications throughout 2019, both based on medical grounds and the need to get access to legal advice. At a hearing date then in February 2020, the respondent made a further adjournment request. He claimed he'd been admitted to hospital with chest pain and breathing difficulties. He, however, failed to subsequently provide legal advice of the same, despite being ordered to do so. So he got the adjournment, but he was told to provide legal advice, never did. The day before the next hearing that was listed, which was due at the end of April, which again was then to deal with both the freezing order and the committal application, the respondent claimed he was now suffering from COVID-19, self-isolating, and wasn't well enough to participate remotely. Attached to that request was for the further adjournment was an isolation note, which stated that he'd been told to self-isolate by the NHS website. An adjournment was once again given, but reiterated the need for medical evidence. The day before the next hearing, on the 11th of May, the respondent wrote again to the court to say his condition had deteriorated and an ambulance was en route to admit him to hospital. Now, in light of that procedural history, it's perhaps less surprising that the application for adjournment was refused by Mr. Justice Mann, notwithstanding the seriousness of a committal application. He did so on the basis primarily that there was no proper medical evidence ever having been submitted by the respondent. And he also made comments about the isolation note that had previously been provided. The judge found that that was simply the result of entering symptoms into a website. There'd been no interview, no examination of the respondent, and so it did not constitute medical evidence in his view. The judge went on to draw adverse inferences, found that he simply did not believe the respondent to have been so ill as to be unable to participate in a remote hearing, proceeded in his absence, found the respondent guilty of the breaches, and then it was only at the prompting of the applicant that an adjournment for sentencing was given. The judge commented that if it had been effectively left up to him, he would have sentenced the respondent there and then. The applicant wanted to give the respondent one last chance to comply. And so the judge instead just gave a very stern warning that there was going to be a serious prospect that the contemnor would be the subject of a substantial prison sentence, which is typical in these sorts of breach of freezing order, disclosure obligations. It's not uncommon to see prison sentences of over a year long. So just to conclude there, where there's been a breach of an injunction, I just have a holding slide for this in terms of that. Where a party prays in aid of COVID-19, we should look carefully as to whether timely or proper compliance was in fact rendered impracticable by COVID-19. Expect robustness from the courts. Short shrift will be given to arguments where the courts think that there has not been adequate evidence provided, and the show must go on. Thank you.
Sarah, thank you very much indeed. I'm afraid I lost you a couple of times in that, but I hope that everyone else was okay with their connection. So, Sarah, I just one quick question on Arkin and Marshall. You know the case in the Court of Appeal where there was a challenge to the validity of the practice direction, and effectively that was upheld. Do you think that's likely to go any further, or are there going to be any repercussions from that?
Yeah, I mean, it's an interesting decision, Richard. It's particularly relevant in respect of possession proceedings. It concerned Practice Direction 51Z, and so the court found that whilst there was, it had jurisdiction in principle to lift what has been an automatic 90-day stay in possession proceedings, it was difficult to imagine a case where it would do so. What's quite interesting about that challenge, whilst it was dismissed, is that there were some interesting observations by the court about the scheme being a true pilot scheme. One of the basis of challenge put forward was that this wasn't really a pilot scheme at all. And there was also a challenge about access to justice under Article 6. I'm not necessarily sure this will be the end of this, but you know, I think that the courts will take a pragmatic view and will try to endorse the spirit of this practice direction, which is clearly intended to allow parties to continue to litigate.
Well, there's obviously going to be some interest there. Thank you very much indeed for that extremely useful, thoroughly practical end to this series of talks. And that is the end, I'm afraid, ladies and gentlemen. And I thank you all very much for looking in, for listening in. If you have questions that you'd like to put to any of the panelists, then please send them to marketing@brickcourt.co.uk. Otherwise, I suppose I should finish by saying something similar to all those press conferences. All I can say is stay alert to things that will come up from Brick Court, which might help you in the future, and stay healthy, because that's important for you, your families and your clients, and save lives, which I'm sure you'll all do anyway. Thank you all very much indeed.